So I was tagged in a video over on TikTok, this one here, which I'll play for you in a minute, and I realized that a lot of people might realize that they are getting ripped off as photographers, or if you've booked a photographer, you may misunderstand the ownership of the photographs and things like that and get into a bit of an argument with the photographer. I've had many clients like this, both on both sides of the fence, and I've had to advise as to who owns the copyright and what's going on here. But there's a lot more to it than just photographs and the copyright within those photographs, all of which I will explain as an overview. But there are, as I say, some very interesting points raised in this video, which I would like to cover as well. So I will obviously do this over on TikTok as well. And this is not to be taken as legal advice, but hopefully provides a bit of guidance. Take a listen to this.
I have a question for solicitors, lawyers, anybody that understands legal copyright. So a couple of days ago, I did a post about photographers and how they have copyright for their images. And that caused up a bit of a stink, and there were hundreds and hundreds of comments between different photographers and people arguing about whether that was the case or not. After Googling, I can see that photographers do own the copyright to the photos that they take. What I don't understand is why is it that photographers own the copyright to the work that they do, but not other art or design or technical related stuff? For example, if you write stunning code or design a stunning website, the client pays for that and it's theirs and they keep it, including the source code. But for some reason, photographers get to own the copyright, which seems odd to me because I could take some photos, charge someone for them, they'd be totally crap, but I own the copyright. But I could also write the world's most beautiful code or build the world's most stunning website and the client pays for that and they keep it. So what's the difference? I have a question.
And so it is a very interesting difference indeed. And it's a misunderstanding, with all respect, but I'll hope to clear that up in this video. So the starting point with photographs and copyright, the starting point is absolutely correct in this video, in that the person that creates the image in the first place is the first owner. The author is the first owner of copyright, save for any agreement to the contrary. So for example, if you commission someone to do your photographs, the photographer will own the copyright in the photographs, and they are providing you with a copy of those photographs for your own personal use, and that is called a license, permission, if you will. If a company is commissioning photographs for use for a specific event or a specific scenario, then it is likely that that is the license that they are granted in those photographs. But the company or whoever it is that takes those photographs still owns the copyright to those photographs. Now, there's a distinct difference between an individual taking them and the individual owns those photographs against someone that works for a company, and it's the company that's contracted to do the photographs, and then the person that takes them, because they're working in the course of employment, they don't personally own the photographs. It's the company that owned the copyright in the photographs. Hopefully all that makes sense so far. Some of the example disputes that I've got involved with before to advise clients, which I'm pleased to say almost always end in our client's favor, is that they, for example, will take photographs for an event, and it's specifically for that event, and it says so in the contract, and that's how it's been priced and so on. But then it transpires that the company has then used those photographs again and again and again on the website and all over the place, and that's not what they were taken for. And if that were what they were taken for, then the photographer would have charged a much higher price. And so the permission to use these is on a limited basis, usually on a limited basis. So the starting point for photographs, this chap here from GenUp Digital over on TikTok is correct in that the person that takes the photographs is the first owner of the copyright, unless they assign that copyright or sell that copyright and all that sort of stuff. However, he goes on to talk about the source code for a website and these kind of things. Now, the misunderstanding there is that there is a difference, a fundamental difference, a misunderstanding that there's a fundamental difference between the copyright in a photograph and copyright in the source code. There isn't. In short, in essence, the copyright will still subsist in the code. And there's a separate type of IP, intellectual property ownership, called sui generis, as in from in and of its own kind type of IP. That would be the content within a database, for example. And so I'll come back to that in a minute. But let's say a company is engaged to create a website for somebody and they write all the source code, and then obviously the company then uses that website. The misunderstanding is that the default position is that they are giving all of the source code along with the sale of the website. That is not necessarily the case. It might be the case depending on the terms of the contract. And there's also a very common misunderstanding and disagreement that comes about. Let's say, let me give you an example. Let's say company A contracts with company B to build them a website. And it's a fantastic website and company A is really happy with it. But then company A realized this website is so good, lots of other people might want to use this website as well. And so they might then want to sell on that website and have their own clients buying this website. And they might sell thousands of them. Obviously, the company that designed it, company B, might get a bit upset about that. And quite rightly so, because they own the copyright in all of the source code behind the website. The company A that has paid for them to have it built will generally just own the right to use that website and within the contract make modifications of it and etc. for their own use. What it will usually not incorporate is the right then to resell and redistribute, relicense and everything else to other people for a profit, because that is obviously not what company B usually is not what company B will have entered the contract for. They are usually not entering the contract so that company A can then profit off their work again and again. That's why when you see various bits of software, you will license the software for your own use. You're not buying the software. You're not buying it so that you can then resell it afterwards. There may be some cases where there's a resale license and you may be able to resell that software, but you'll certainly have to pay a much higher price and there'll be certain restrictions. And you can become a reseller and that then becomes something like a franchise and that sort of thing. So then you can start to resell them. When you buy a photograph or the license for a photograph, you are usually buying it for a one-off use or very limited use. And if you want to buy it for much broader use, and the distinction here is between commercial use, private use, and so on, you can obviously pay different prices depending on what you're buying that for. But back to the websites and code design and all that sort of stuff, the first owner is going to be the company that's created the website and written all of the code. Now, some people might then say, well, other companies all the time will copy the structure, the functionality and everything else of a given app or a given website. Now, that is okay to a degree. As I say, it's only to a degree, because if a company is observing the functions of an app, what it does, how it does it, and they create their own app from scratch to do the same thing, then that is broadly going to be okay. Where it will fall foul of intellectual property law is if it uses a certain amount of information that would be within the database on the original app and then infringe on the sui generis rights, the content within that database. And that might even be just functional information and data within the database, not just user-generated data itself. We've come across situations before now where people have been trying to recreate an app and they've pulled out so much information from the original that they are infringing on those rights, the rights of the information and the of its own kind type of data and information contained within that database. As I say, we get quite complex when we start talking about those kind of intellectual property issues. But the very simple principle of copyright law is that whoever uses the skill and know-how, the time and effort to create something, and it is more than de minimis, more than just a minimal amount. So for example, you're not likely to be able to copyright a single letter. And there's a very interesting case which I am putting some time into creating a video for, so please do make sure you subscribe for that, to do with Apple, funnily enough. So make sure you subscribe for that. It's a very interesting topic, but hopefully this has given a lot of people, but hopefully this clears up a lot of questions people might have, whether you're the photographer or someone commissioning photographs, who owns what. And the best advice for anybody is to make sure that you understand, if you're taking the photographs, you understand what you are selling, whether you are selling the copyright or just the right to use them for one purpose. If you are buying the photographs or commissioning the photographs is the proper term, if you're commissioning the photographs, what it is that you get. Do you get the raw images, which is unlikely? Most photographers will not hand over the raw images as a standard anyway. They will usually take the photographs with raw, they will do some manipulation and standard editing with them, give you those, and it's the license to use those. I suspect it might be changing over the years, but I do know a lot of photographers that do not hand over the raw files for these photographs. And if you don't know what I mean by the raw files, then you don't need them. If you don't understand what they are, you've probably no need for the raw files in the first place. Someone might say, make sure you get the raw files, but if you don't know what they are and how to use them, then they'll be no use to you anyway. For example, I record all of these videos that I do for you here in RAW, and I put a log file on top of it. And again, if you don't know what that is, you have no need for the raw files. But hopefully that's some interest to you. Please do make sure you subscribe. And as always, thank you for watching.